Good afternoon. My name is Margaret Raymond, and I'm the Dean of the University of Wisconsin Law School. It is my great pleasure to welcome you to the annual Fairchild Lecture. This lecture series recognizes and honors Judge Thomas Edward Fairchild, who served on the United States Court of Appeals for the Seventh Circuit from 1966 until 1981, and then a senior judge from 1981 until his death in 2007. Initiated by Judge Fairchild's former law clerks, the lectureship brings to the University of Wisconsin Law School a distinguished member of the legal profession from the bench, bar, or the academy to speak on a topic of importance to the profession. Judge Fairchild was born in Milwaukee and was a graduate of Cornell University. He attended this law school, graduating in 1938, practiced law in Portage, served as an attorney with the Office of Price Administration during World War II, and practiced with the Milwaukee office of Foley and Lardner. In 1948, he was elected Attorney General of Wisconsin, and in 1951 was appointed U.S. Attorney for the Western District. A year later, he resigned to run against U.S. Senator Joseph McCarthy. He was defeated, but was later elected to the Wisconsin Supreme Court, serving until 1966, when President Johnson appointed him to the Seventh Circuit. I have in the past had the pleasure of sitting with some of Judge Fairchild's former clerks and hearing them share stories about the extraordinary impact this remarkable jurist had on their lives and careers. It is our honor as Judge Fairchild's Law School to be able to acknowledge him with this lecture series. I'd like to take this opportunity to welcome Judge Fairchild's son, Tim, and his wife, Maya Fairchild, who are with us today. It's wonderful to have you here. I'd also like to welcome those of you who are Judge Fairchild's former clerks. Thanks so much for being part of our community and for sharing this day with us. It is now my pleasure and privilege to introduce today's Fairchild lecturer, Collins Fitzpatrick. Collins Fitzpatrick is the Circuit Executive for the United States Court of Appeals for the Seventh Circuit, a position he has held since 1976. He began his work at the circuit in 1971, clerking for Judge Roger Kiley and Chief Judge Luther Swigert, and he served as the senior staff attorney in 1974 and 75. He is a member of the ABA and is active with the Seventh Circuit Bar Association, the Chicago Inn of Court, and the Chicago Bar Association. He serves as an arbitrator on large commercial cases for the American Arbitration Association and the CPR Institute for Dispute Resolution. He is a contributing author to the Attorney's Guide to the Seventh Circuit Court of Appeals and a contributing author and editor of the Practitioner's Handbook for Appeals to U.S. Court of Appeals for the Second Circuit. He is a frequent speaker to law and bar association groups, has been invited to speak with and consult with the justices and staff of the Supreme Arbitrage Court of the Russian Federation, the Federal Court of Australia, the Laotian Judiciary, law professors and justices of the Supreme People's Court of China, and judges and prosecutors throughout Turkey. He obtained his bachelor's degree from Marquette and his law degree from Harvard, but we can still be friends. In addition, he obtained a master's degree from the University of Illinois at Chicago and is a certified fellow of the Institute for Court Management. Collins and his wife Mary have 4 sons, 3 daughters-in-law, and 8 grandchildren. He enjoys doing volunteer work, playing basketball and hockey, competing in triathlons and long-distance races, and traveling the world. His commitments include not just federal law, but golf. He is a trustee of the Evans Scholars Foundation and a director of the Western Golf Association. Please join me in welcoming Collins Fitzpatrick as our 2014 Fairchild Lecturer.
Thank you very much, Dean Raymond. I want to thank the University of Wisconsin Law School and the Thomas Fairchild Lecture Committee for the honor and privilege of presenting this lecture. Tom Fairchild was a great friend from whom I learned much. He was a gentleman and a jurist, and a giant at both. Plus, he was a lot of fun. I worked with him from 1971 until his death in 2007. If you do not know much about him, I recommend his oral history, which is on file. You can get it on the internet at the United States Court of Appeals Library. I highly recommend it. After I was invited to speak, I gave a lot of thought to a topic that Judge Fairchild would want discussed. Let me tell you about my thought process and 3 experiences that brought me to my topic. As a young law student, I watched as Attorney General Elliot Richardson and Deputy Attorney General William Ruckelshaus resigned rather than follow President Nixon's order to fire Archibald Cox, the special prosecutor for the Watergate crimes. This was referred to as a Saturday Night Massacre. At that time, I and some of my fellow law students thought that President Nixon might be engaged in a coup d'etat. We were wrong, and eventually Nixon resigned in disgrace, but he did resign. The Constitution worked. As a brand new lawyer, I represented a high school student at an expulsion hearing. The hearing officer was the assistant principal, who also was a prosecutor of the charges. At the hearing, he added 9 additional infractions to the 2 for which we had been given notice. The hearing officer / prosecutor introduced no direct testimony, only hearsay as to what others had told him. My client was expelled. The hearing denied my client the due process of law in many ways, but he was reinstated thanks to a decision of a federal judge. The Constitution worked. Lastly, I was on Capitol Hill on September 11, 2001, and could see the smoke from the Pentagon and listen to reports of another plane heading for Capitol Hill or the White House. Subsequently, our government did many things which, in my view, contravened our proud Anglo-American history of civil liberties. I certainly never thought that the United States of America would incarcerate prisoners for long periods of time without charges and a trial before an independent judge. Nor did I think that our government would institute torture policies to get confessions. The continuous question for each of us is the Constitution still working? Tom Fairchild was a great defender of civil liberties and the rule of law. As a candidate, he opposed Wisconsin Senator Joe McCarthy, and as a lawyer, he opposed McCarthyism. He advocated for civil rights before it was popular to do so. So I think that Tom would approve this message. In fact, he is probably sitting at heaven's equivalent to the Rathskeller, having a beer and listening. All who knew Tom Fairchild enjoyed discussing serious issues like the Fourth Amendment, as well as being entertained by his stories and jokes from the Tri-County Bar Association's annual summer meetings. One of the foundation stones for the rule of law and a democratic way of life is the Fourth Amendment. I want to address the issue of the balance between security and liberty. How do we protect people from harm while trying to make sure that the government's methods of providing that security do not deprive people of their liberty, their freedom from unwarranted privacy invasion by the government? One of our great American leaders was Benjamin Franklin. He was a key delegate to the Constitutional Convention that wrote our Constitution. In 1775, while the 13 American colonies were still under British rule, and a year prior to the Declaration of Independence, which Franklin also helped write, he said, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." This is really a very important point. Let me just repeat it. Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. There are 2 universal principles of the Fourth Amendment of the United States Constitution. The first principle is that people are to be secure in their persons, houses, papers, and effects from unreasonable searches and seizures. The second principle is that no warrants shall issue except upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. 240 years ago, there were no cell phones, internet, cameras, planes, drones, knowledge of DNA, or Google Glass. There were no computers to keep track of all the information. Nor was there a national security agency or similar foreign country agencies to track all that information. The Fourth Amendment bans unreasonable searches and seizures and general warrants. It is not long and it is not very detailed. How do the principles of the Fourth Amendment from the founding days of the American Republic apply to our era with government searches of DNA databanks, recording of internet and telephone traffic, facial recognition software with widespread camera coverage from drones and from street-level cameras, national security letters, searches authorized by national security letters of health, utility, consumer, and financial records, heat sensors of private spaces from public ways. How do we protect our citizens from those who would kill by coming to a gathering like this with an explosive vest or a backpack? Let's look at the history of the Fourth Amendment. Like many ideas that Americans think originated in the United States, the principles of the Fourth Amendment have a long developmental history. We in the United States have greatly benefited from ideas developed throughout the world. 4,000 years ago in Eshnunna, which is now modern-day Iraq, there was a provision for death to burglars and exoneration to a person that slew the burglar coming into a person's home. In Byzantium, Roman Emperor Justinian's code provided that a free man could not be summoned from his home, as it was everyone's safest place, his refuge and his shelter. The principle developed is that there's one place where you are secure, your home. The British were the most direct source for the principles enshrined in the Fourth Amendment. The British thought that a person's home was his castle and should not be violated without proper legal process. That idea initially appears in British legal literature in the 1300s. In Saman's case, in 1603, the British court recognized that a person could defend his home against entry by the king's agents unless there was proper notice. A great British statesman, William Pitt the Elder, said, "The poorest man in his cottage may bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter. All his force dares not cross the threshold of the ruined tenement." The second part of the Fourth Amendment prohibits general warrants. Warrants to seize or search need to be specific. The government cannot search everyone's house for stolen money from a bank. There needs to be probable cause to think that the money is in a particular building or house. Famous British judge Lord Coke said that the background for the principle of no general warrants emanates from Article 39 of the Magna Carta, when King John at Runnymede in 1215 was forced by the nobles of his kingdom to abide by the law. Article 39 of the Magna Carta, which was issued as a result, provides, "No free man shall be taken or imprisoned or dispossessed or outlawed or banished or in any way destroyed, nor will we go upon him or send upon him except by the judgment of his peers or by the law of the land." The British provided the doctrinal background for the Fourth Amendment, and the British were also the cause as to why the Fourth Amendment prohibited unreasonable searches and general warrants. The American colonists saw the British rulers as being unfair. The British government had for a long time used their laws to conduct general searches in homes, warehouses, and other buildings looking for untaxed goods, stolen property, seditious publications, criminals, military deserters, and vagabonds. In the American colonies, the British government looked for many ways to tax the colonists to support the colonial government. Excise taxes on liquor, stamps, and other goods, and customs tax on imported goods were a mainstay of British government financing of the American colonies. And surprise, surprise, the colonists tried to evade paying those taxes. To combat tax evasion, the British and the American colonial governments used general warrants and writs of assistance to look for untaxed goods in homes and other buildings. General warrants were granted by a judicial officer to do searches and seizures for crime, but not specifying particular locations. Writs of assistance were a general authorization to search for vagabonds, military deserters, and untaxed goods. Both legal documents authorized dragnet searches. Searches would be house to house and in the middle of the night for evidence of crime and suspects to arrest. These general warrants and writs of assistance were very much opposed by Americans, and they were the impetus for the Fourth Amendment prohibition against general warrants and the requirement that searches be reasonable. How do you apply those principles to the surveillance and seizure techniques of today's world. The drafters of the Fourth Amendment wanted to require specific warrants and reasonable searches and applied them to more than a person's house. Fourth Amendment provides that people have a right to be secure against unreasonable searches and seizures to their persons, houses, papers, and effects. And that's pretty much all there was at that time. There were no extensive records or dossiers other than what a person kept, usually at their home. And houses included offices, shops, and barns. Fourth Amendment also contains a total prohibition against warrants unless issued upon probable cause by a judge, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Warrants had to be specific for the search and seizure and had to be based on probable cause, which, as you know, is a legal term still in use today as the standard for arrest or search. Over the years, the Supreme Court of the United States and other American courts have parsed the Fourth Amendment words. For example, eavesdropping devices were once allowed if they did not pierce the wall of the building. If they did pierce the building, such a piercing would have been a trespass to property. So if you could listen to a conversation inside a house from outside the house with a very sensitive listening device that didn't penetrate the wall, under Olmstead v. United States, that was permissible. It wasn't a trespass to the property. 60 years later, the Supreme Court reversed itself in Katz versus United States, holding that a defendant had an expectation of privacy which was violated by the warrantless electronic surveillance, even though there was no piercing of the wall. The Supreme Court in Katz did say that the evidence that the police had collected in that case would have sufficed to have obtained a warrant from a judge if the government had sought a warrant. They just could not have used the eavesdropping device without a warrant. The Supreme Court's Fourth Amendment standards of a person's reasonable expectation of privacy and a person's right to be free from trespass have led to some interesting decisions. The Supreme Court in Smith versus Maryland held that no warrant was required to install a pen register on defendant's telephone which recorded that he had called the victim. No warrant was required, as the defendant had voluntarily disclosed to the telephone company whom he was calling when they dialed. Nor is a warrant required for bank records, as the customer disclosed the information to the bank. That was a principle in United States versus Miller. Similarly, you disclose to businesses how much electricity you use in all of your credit card purchases. The records are obtainable without a warrant by the government under the theory that you have already voluntarily disclosed the information to a third party, and therefore you no longer have an expectation of privacy in the information. But recently, in United States versus Jones, the Supreme Court held that taking a GPS system, global positioning system, and attaching it to a car requires a court warrant. It was the Olmstead trespass again, although some justices referred to the expectation of privacy. In my opinion, the Fourth Amendment does not restrict the search of one individual who is under suspicion. It is a dragnet searching of millions of records by the government in order to find an individual that is objectionable. Courts have so parsed the Fourth Amendment that it is fine to obtain the records of all of us as we, like the plaintiffs Miller and Smith, disclose the information to third-party companies. When courts so parse the words, they miss the point of the Fourth Amendment that there are to be no dragnet searches. Mass collection of data is a dragnet search. If the government wants to collect information on an individual suspected of a crime or gather information about possible criminal suspects, the prosecutor needs to explain to a neutral judge the basis for the warrant, the probable cause to issue the warrant. What is the evidence of a crime being committed by this particular suspect, or the probable cause to believe that this type of search will lead to evidence of the crime? The request for the warrant requires the prosecutor to focus on a particular person, place, effect, or thing to be searched or seized based on the crime being investigated. And the terms of the search need to be reasonable. Searches should be commensurate to the purpose of the search. Investigators should not collect DNA samples from all students in a school because one might have been involved in a rape, as a rapist wore a sweatshirt with the school's logo on it. A mosque should not be searched on Fridays when full of prayerful attendees, even though one of the congregants may be a criminal suspect. All phone records of everyone should not be collected to learn who is calling persons in Somalia or the Kurdish area of Iraq or the tribal areas of Pakistan. It is different if the records are requested are for those of a person who is calling persons suspected of being threats to national security. Then you have probable cause to obtain a search warrant for the person's records. District of Columbia District Judge Richard Leone in Clayman versus Obama, this was a late December decision, explains in detail how the National Security Agency searches occur. The government goes to the Foreign Intelligence Surveillance Court to get approval based on a suspected phone number or IP address. First number is called the seed. The records of numbers communicating with the seed are called the first hop. Then the first hop numbers are searched to learn their context. That's called the second hop. Then the second hop numbers are checked to learn their context, the third hop. You can get some idea of how many numbers are checked when I tell you that we're dealing with 5 years of records for each contact. If you estimate how each of you, how many telephone calls you've made, how many emails or internet contacts you've got over 5 years, and that's just a seed. First hop is all those people you contacted, and then the government checks all those people who you contacted, etc. Judge Leone, by the way, held that the program violated the Fourth Amendment as an unreasonable search. 11 days later, Judge Pauley of the Southern District of New York said that the program was constitutional in American Civil Liberties Union versus Clapper. I commend those decisions to you, as well as the December 2013 report and recommendation of the President's Review Group on Intelligence and Communications Technologies, and the January 13, 2014 response to the report, incorporated in a letter to Senator Dianne Feinstein from District Judge John Bates, who was the Chief Judge of the Foreign Intelligence Surveillance Court. How do we apply the principles of the Fourth Amendment, reasonable searches and seizures, no general warrants, to the war on terror? In my opinion, the war against terrorism is not really a war unless the terrorists are being supported by an actual or pseudo-government. In that case, it is an actual war, and the existence of the nation could be at risk. In many instances, we have citizens as well as foreigners who want to overthrow a government. Some revolutionaries are seen as good and some are seen as bad. Compare Thomas Jefferson, Kemal Ataturk, Mahatma Gandhi, Nelson Mandela, and Martin Luther King with Pol Pot of Cambodia and Charles Taylor of Liberia. I'm sure a lot of persons besides the then current government officials saw the first group as terrorists, although now we all recognize the first group as heroes. In times of real war, where a nation's security and existence is at stake, many rights are suspended. In the American Civil War, the writ of habeas corpus was suspended. Military commanders did not seek court orders before searching buildings for enemy soldiers or supplies, and there was no right of trial by jury for captured persons who were suspected of being rebels. In World War II, loyal Americans of Japanese descent were forcibly removed from their homes and sent to internment camps. Their homes and farms were taken without due process of law. The formal apology from the United States and reparations many decades later did not make up for the denial of their liberty and property. I mention this as I'm not talking about wartime suspension rights. I'm talking about the application of the Fourth Amendment principles today in the war against terror. We all have access now to more total information than all the top government leaders who were in office prior to 1970. You have at your fingertips on your smartphone or your iPad more information that can be found in print in the largest libraries of the world. I can check the weather in Istanbul for the next 10 days, and I can check the seas in Papua New Guinea or elections in Ukraine. This is a result of the computer and the internet. But like many inventions, they have good and bad points. We now have access to an infinite amount of information, even if you are in the most remote location of the Earth or even in outer space. But the disadvantage is that this technology also allows businesses to gather all sorts of information about you and share it with other businesses. And it allows governments to gather and store all kinds of information about you that is already gathered, or to obtain it from those businesses without notice to you. The government can collect this information without any court review using national security letters, which they send to businesses such as your employer, cell phone company, internet provider, credit card company, health provider, bank, and many other businesses that gather information about you every day. Even before I had a smartphone, which I can identify where I am at any one time unless I take the battery out, and then I lose all the information, so I don't do that. But I realized early on the power of this technology when I was skiing in Colorado with my family. I purchased my ski ticket with my credit card, which was then read by the chairlift attendant with a barcode reader. Chairlift only served expert ski slopes, so the information gathered could easily tell you how many times I went down the expert slopes and roughly what my speed was. But it wasn't anywhere near the speed of my sons. Although the government may have no use for that information, life and health insurance companies might be interested in what I did as a hobby when determining my insurance premiums. Or maybe my employer would not like my off-hours hobbies. Companies have not only a record of where you shop with your credit card, but what you buy. Liquor, cigarettes, ice cream, potato chips. I mention this as every day we give out a lot of information to others about how we live our lives. My elementary school teachers used to remind me, they were nuns, that God is watching me. Well, God's getting a lot of help from the NSA and these other government agencies. But how does this relate to our topic? Well, is it permissible for the government to gather everyone's health records so they can identify persons with social diseases? Or can the government access everyone's credit card records to match their expenditures to their declared income? What if the government collected records of everyone's purchases so that it knew everyone buying fertilizer, pressure cookers, remote control devices, and other potential bomb-making equipment so it could cross-check with records of regular participation in neo-Nazi and militia organizations? How do we apply the Fourth Amendment to these types of government searches? We cannot turn back the clock. Information technology is here to stay with its great potential to collect and store and cross-check information. It is one thing to have your cell phone company know whom you called and for how long, or your internet company to know whom you are communicating with, or your credit card company to know how you spend money. But do we want the government to have access to all of that information without suspecting us of a crime? If you are looking for answers to the questions of what searches a government in fighting the war against terrorism should allow, I have no answers. But I can point you to the principles of the Fourth Amendment that have served us well. Searches and seizures are to be reasonable, and the request for a specific warrant should be presented to a neutral judge based on probable cause that a crime has been committed, is being planned, or that this particular person committed a crime. There should be no dragnet searches, whether it be a search of everyone in this room or a door-to-door search of houses, as was banned by the Fourth Amendment when it was drafted. Similarly, those Fourth Amendment principles also ban the government collecting information on everyone because it might lead to evidence of a crime. Edward Snowden is seen by many as a traitor to the United States for disclosing the secrets and the secret methods that the National Security Agency is using to collect information on Americans and others around the world. Others see Snowden as a great hero who did the right thing by disclosing what the United States is doing. History will judge. In any event, Mr. Snowden brought to the forefront this issue. Should there be any limits on a government's collection of information on its citizens in order to stop criminal activity? According to the reports, the National Security Agency collects all of our internet and phone conversations, but only analyzes whom we contact. That's the whom is the phone number or IP address, not the individual. The length of the contact, and where the computers or cell phones are located during those contacts. My understanding is that the text of the messages or the conversations are stored but not reviewed unless there is specific evidence that is linked to a security threat. I am sure that we will soon have, if we don't have now, ubiquitous camera recordings coupled with facial identification software to identify where specific individuals were at a specified time. Technology has provided the government the power to collect store, and cross-check all kinds of records of citizens. I would venture to guess that there is a potential for the government to know much more about each of us than even we can remember. United States President Nixon and Federal Bureau of Investigation Director Hoover illegally collected information on opponents. I am reasonably certain that they would have used the adverse information gathered under the current United States data collection programs as well. There are already persons arguing that the NSA records should be used to gather evidence on murderers, child pornographers, and drug dealers, or to find missing persons. How do you tell the public that the government gathers this information only on terrorists? I think that it is reasonable to assume that if this information is gathered, it will be used legally or illegally for other purposes. The wholesale gathering of telephone and internet records is not limited to the federal government. The Wisconsin Supreme Court has under advisement the case of a defendant whose cell phone was tracked to his home by Stingray, which is a mobile device that state and local police can use that mimics a cell phone tower and gathers the location of the cell phones within range. The Fourth Amendment laid down two good principles. Searches and seizures are to be reasonable, and there should be no general warrant dragnet searches. Remember what Benjamin Franklin said: those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. Thank you for the opportunity to speak to you today.
Thank you for your presentation. I'm wondering about a certain kind of commodity that we drive, our cars, and our privacy within those vehicles. It's as if we've got almost everything within those vehicles for working. Sometimes we could even take a little nap in those cars because we're working so hard and all that. And it becomes a kind of home. Now, we have some sorts of search and seizure, that is mandated within that vehicle. But what about tracking the location of that vehicle? Many of our technologies, of course, afford that, and I'm just wondering what the privacy implications would be for that within the kinds of structures you've designed.
I would apply the same principle. If you've got probable cause to think a crime's been committed, then I have no problem in going to a judge and getting a warrant to search the computer on the car that discloses a lot of information about your driving on a particular day or a particular week or whatever it is. But what I would not want is for Ford Motor Company to be regularly turning over all that information to the government, whether it be the federal government or a local government, for all cars that ever came into the shop. So the bottom line is I think the principles of the Fourth Amendment really serve us well. Searches need to be reasonable. They need to be based on probable cause. We need to use the judiciary as a filter to make sure that we don't have prosecutors who are too rambunctious.
Just as a follow-up, should we have the right to ask that those communication devices be disabled so that our cars would not be trackable? Could we go to Ford and say, I don't want that feature?
I assume you can, unless there's some national traffic, something from the Department of Transportation that requires that to be activated, such as requires, for example, seatbelts to be worn. You can make the argument much easier for seatbelts than you could for this computer to be working at all times. I mean, I know of nothing that would prohibit you from disconnecting that. But I just don't know. I don't have an answer to the question. But as I said, there needs to be a focus on an individual. We shouldn't be collecting all those records of everybody.
Do you really think that it's government right now is the biggest threat to us? Or, I mean, I anticipate that Amazon probably knows more about me than the federal government does. And do you think that Do you think that the government should play a role in regulating the amount of information that is collected for commercial purposes, so that they know what advertisements to send me over the internet and so forth? But it could be used for more worse purposes, I suppose.
I personally would have no problem with a statute that forced companies not to collect certain kinds of information. I don't know why we couldn't regulate the businesses in that way, but it needs to come through the legislative process. But I see it much more of a problem when the government collects it than a business, even though I would think that the business probably may do a better job of collecting all the information. That's spoken as a government employee.
The European Union is considering zorking up their data protection principles, and one of the things they're considering is putting in a provision, either the right of erasure that each individual would have, or the right to be forgotten. So would you think that would be a reasonable way for us to protect our privacy?
Absolutely, I would think that'd be that, as I just mentioned before, I think legislation to do that, I have no problem with. It regulates the businesses. But my thrust of my talk is to make sure that the government doesn't keep a backdoor key to all that information. And even though it's erased for business purposes, they have access to it. Ann, did you have a question?
This may be another year's topic, but certainly I don't think it's. I think it's a pretty open secret that the supported by oath or affirmation is often made a mockery of by cops and prosecutors who, say what they need to say to get the warrant. Do you have a thought on how we address this?
I think that's why we have independent judges to reject. We just had recently in Chicago, 5 police have been, can't remember if they've been indicted or if it's a civil rights complaint, but they basically came in and said, they repeated the same story, each one of them, about this arrest. Unfortunately, they didn't turn off one of the cameras on one of the police cars, which went against everything that they said. And one of the judges, a state court judge, was livid about that and called for their, and they've all been at least relieved of temporary duty, a couple suburban policemen and a couple from Chicago. But to answer the question, I think that it's having the neutral judge look and evaluate the policeman. It's having our cross-examination, our adversary system. There's many good lawyers who've tripped up liars on the stand. Somebody.
This may be an unfair question to a government employee as well, but you referred a couple of times to neutral judges. And given, of course, that there's a lot in the press about the political leanings or speculation about the political leanings of the judiciary, do you think that the system is working as it should in terms of checking the executive branch?
I think that the system works pretty well about checking the executive branch. It's always, I always like to tell foreign folks in the judiciary or in law that the power of Judge Crabb or Judge Conley to tell the President of the United States what to do, they're absolutely amazed at that power. And just like, as I mentioned about Nixon resigning, he turned over the tapes because he followed the law. Am I concerned about the politicalization of the appointment and elective process? Yes, very much so. I think that these are important jobs, and whether you be a liberal or a conservative or in between, or Republican or Democrat or whatever else, in my experience, and I've known hundreds of judges now, judges want to do a good job. They want to be respected. I've had 5 trips to Russia to talk to the judges over there about the independence of judiciary and the rule of law. Makes me very sad as to what's going on right now, but those judges really wanted to be respected. They want to do a good job. They don't want to be getting a call from the commissar as to how to decide a case. So the same thing clearly applies to most all the judges that are elected and appointed. They want to do a good job. They do check their credentials at the door when they're appointed or elected. At least that's how I've seen it, and I don't think I've got cataracts that I can't see it clearly.
I just want to make sure I understood you. You said something about if a person voluntarily gives over information to a third party, such as a company, then the government doesn't need to get a warrant to get that data. Well, I went to the hospital yesterday morning to visit my newborn granddaughter, sorry. When I look in the mirror,
And she's here today.
when I look in the mirror, I don't recognize the person. And the nurse came in and took a DNA sample, and I was sort of shocked. But that's a policy now that they take the DNA. So, although I guess we can't say she gave consent, but that will be data that would be available to through a third party. So how do you think the Fourth Amendment, I mean, it just seems to me that technology is moving so much faster than the law that this is a very difficult issue.
It is a difficult, but my answer to that is the same as I've been giving. You know, if there's reason to get the information because of a crime, let's say that, not this situation, but another one, you wanted to identify a body. Using the DNA records to identify the body, it seems to me is fine. Using the DNA to identify a rapist is fine. Using everybody's DNA is not fine. Not having some kind of looking through 300 million DNA samples in order to find a person. I think there needs to be a crime. There needs to be some reasonable probable cause to look for that. And as far as the hospitals are concerned, that's something that was already mentioned about, legislation. Should we have legislation to erase some information? Maybe some information we'll never erase, fingerprints, DNA. But that's why, in my view, the more I thought about this issue, the more it comes back to the wisdom of our professional ancestors who drafted the Fourth Amendment as well as all the other provisions. It's very simple, but I think that it gives us guidance, much more so than whether there was a trespass to the wall or whether somebody had a reasonable expectation of privacy. In today's world, I'm not sure where the reasonable expectation of privacy exists anymore. So having no dragnet searches, having searches that are reasonable, those are the things that seem to me to be important.
You made several references to the warrant requirement, but the United States Supreme Court has established numerous exceptions to the warrant requirement, and I'm sure you must have comments on that.
Well, I think, following up on Judge Bauer's last year's speaker, the drug war, in my view, has created bad law, bad constitutional law. A lot of probable cause to stop vehicles, stop other people on the street, but that's a topic for another time. We don't have the time to go into it, but that's my own view, that we've had a lot of bad Fourth Amendment law, a lot of exceptions, as you point out. And that's the problem of parsing the Fourth Amendment and trying to fit things into categories where they don't, in my view, fit. My view is follow the general principles. Don't get lost in the minutiae along the way.
Well, is there one particular exception to the warrant requirement that you think is a mistake?
Oh, I think on the, you mean on the requirement of a warrant or on the requirement, or that you don't have to get a warrant? Which way are we going?
Any exception to the warrant requirement? I mean, consent, for example. One, but
Absolutely. If there's an emergency situation, I mean, a threat of somebody dying, yes. But that's not a dragnet search. That's not what we're talking about here. That's not searching everybody's yard and everybody's house in Madison. That's searching a particular area and not going to get a warrant because you think somebody might die in between, before you get the warrant. And now that we're getting warrants electronically, that's going to weigh in the requirement, in my view, that more warrants be granted, because it's police go into a place and they say, well, we don't have time. We're afraid that they're going to destroy all the evidence. We don't have time to go back to the courthouse to get the judge to sign the warrant. Here's the affidavit. I do it electronically. It's recorded. Judge, can we search? Yes. Written order to follow.
Thank you. Please join me in thanking our students.
Before the dean speaks, let me just repeat again. I think that you would all be well served to look at the oral history of Tom Fairchild. He was a great person, and you'll be very entertained by it, I think. So.
We'll look forward to it. We have a present for you. And many of, I think everyone appreciates the spirit in which it is offered, though some people are probably a little surprised by how darn ugly it is. This is a gargoyle. It's the iconic symbol of the University of Wisconsin Law School. It means a lot to us, and we offer it to you with our sincere thanks for being our Fairchild Lecturer.
Thank you very much, Dean. I have to tell you that because of these overseas trips, I've gotten a lot of different things, and my wife Mary always says, "Oh, is that going to the office?"